All right, folks, thank you for joining me today. We have a very special guest, Fred Rispoli, out of California, has filed a class action lawsuit here against Coinbase in regards to our Songbird and Flare tokens. This is the type of claim that I've been talking about we need to have made in the XRP community, and just understanding our rights as digital asset investors. I think it's very important to be sitting down and having these conversations. Thank you for joining us, Fred.
Hey, thanks for having me on the show.
It's an absolute pleasure. And I hadn't really, I came to know of you just recently before you filed this lawsuit, but you kind of stepped into the conversation here with the XRP community, and I appreciate you for doing so. But why don't you tell the audience real quick about who you are and where you've been?
Sure. I am an attorney. I'm licensed in California and Arizona, and I started out my career in a very large law firm, the type of law firm that is being utilized by Ripple, by Chris Larson, by Brad Garlinghouse. And I started out doing massive billion-dollar class action litigation. And, that sounds a lot more sexier than it is, because I was just low man on the totem pole when I came right out of law school. So I was on billion-dollar claims, but I was just buried away doing document review, drafting motions, that other people would argue and finalize. So I've got, the low-level experience on that side. And then ultimately just realized that my heart wasn't into that kind of law of trying to basically help corporations get out of things and find exemptions or loopholes to get out of certain things. So I started getting into the plaintiff side of work and really started doing nursing home abuse and med mal litigation, where I would help people that were injured at nursing homes, people that had a hospital system, medical system screw them over, and they got hurt or a family member died. And I just started doing that kind of stuff, started my own law practice. And then I got into digital assets in 2018 in January. A friend of mine, said, you have to really get in this, started talking about Bitcoin. It had just, started crashing from 20K, and started talking about XRP and some other things. And then I got hooked. And so I was in the space right around then. I've been following Bitcoin since it started, but never bought anything. I can still remember, I always tell everybody the story of when I saw it go up to $600, thinking to myself, oh, I missed the boat on that one. Not going to buy Bitcoin now. And so I, wanted to do a little more. I was getting a little burnt out from the med mal, death and destruction side of it, and started getting into crypto law. Got really upset. I think a lot of people know me from when I filed a complaint against Bill Hinman and Jay Clayton personally for manipulation with the XRPL network. We withdrew that claim, although we're still taking people that are interested. Go to xrplawsuits.com if you're interested in signing up for that. We decided there's a whole lot of stuff that happened in the week after that was filed that it's probably worth it for another show. But we withdrew that, said let's let the SEC lawsuit play out a little bit. And so I've just been getting more and more involved and being more vocal publicly about the case. And I just started working with another company, Reaper Financial, which is a great company that I would recommend everybody checking out. It's pretty cool. We filed an amicus brief in the Ripple case. And then, I've been trying to get this Songbird class action for a while, and I'll go into the specifics in a little bit. And finally, we were able to file it a couple of weeks ago.
Yeah. So that's got everyone's attention within the XRP community. I definitely am looking forward to getting into that. Before we do that, though, I want to talk about just the general state of this cryptocurrency market. You had put out a pretty interesting tweet about how the Genesis bankruptcy was going to affect Gemini. We continue to watch the insolvencies. We continue to watch this space go through some issues and turbulence. What are your general thoughts on the state of this cryptocurrency market right now?
So I subscribe to the essentially 4-year cycle that's been happening. I think, I'm not a TA person, but it seems like from everything I follow and people I listen to and watch that that's playing out, pretty regularly. And, at some point it won't, but for now it does. And so I think we're in that bear market accumulation. We've probably bottomed out, barring some crazy unforeseen circumstance. And, we'll be in that slow slog upwards. And then a little bit after the Bitcoin halving, we'll be right back into a rocket cycle again. And everybody, please remember to take your profits that time, because I didn't do it myself at the last one. And, I got to really remember that. But I think that's where we are right now. And just as a general matter, and we've seen Bitcoin kind of start ticking up and everything else is ticking up. The bankruptcies, if you want me to go into any specific area with those, but, there's just a few certain things that people need to know when you have a bankruptcy, which is, in any bankruptcy, it starts a stay of litigation of everything else. Stay just means any other claims are stopped. You can't go forward with them. This happened in one of my med mal cases, where a doctor we were suing, her insurance carrier went bankrupt, and somehow the court said, well, now you can't sue the doctor, even though I wasn't suing the insurance company. And that bankruptcy has been going on for 6 years. And so we couldn't go forward against that doctor in litigation. So what that means with Genesis, for example, is everybody, Gemini and Genesis, were getting sued in a class action for the EARN program, or rather not being able to get their withdrawals out. And now the part of the case against Genesis can't go forward anymore because there's a stay, but the part against Gemini can. So Gemini's stuck holding the bag. They might try and argue that they should be stayed as well. It's very fluid. This is all just happening. But now Gemini's stuck holding the bag, having to continue to shell out for lawyers, at least in this case, while everything else with Genesis is stayed. And Genesis had all of Gemini's funds and money. So, they're doubly screwed.
Right. So for me, I'm seeing this situation. I'm seeing the exposure that Digital Currency Group has here. And I do kind of worry that we haven't cleaned out enough of this space yet. But it is interesting to see how some of these bankruptcies filings and proceedings have kind of gone so far. But I would surely appreciate if you said like we have bottomed out and we can start to move forward. But what I worry about is the contagion seems to still be spreading within this case, even though, like you said, in these bankruptcy filings, they kind of put a stay on any other future litigation. But I understand that. Now, maybe you could speak a little bit more on that. So you're saying that no more lawsuits or claims can be filed against Genesis at this point because they have filed for Chapter 11 protection.
Yeah, and I'm not a bankruptcy law expert, so I'm going to speak in generalities. Like any major piece of U.S. code, there's all sorts of exemptions, carve-outs. You can go to the bankruptcy court specifically and say, hey, bankruptcy judge, please remove this stay in this case, because it's very important. We have to keep it going. Usually that's not successful, but you have an option like that. And that's not to say that everybody involved that wants funds from Genesis, that doesn't mean if they already have a lawsuit, they stop doing anything. You have to be very involved with the bankruptcy proceedings. Make sure you file your claims, make sure your lawyer gets on the right committee. And so, to be more specific about Genesis, and you mentioned Digital Currency Group, which is really fascinating. I pulled the declaration of one of the, I want to say the directors, I believe it was, filed on January 20th. So, this is just last Friday. And that was basically discussing a lot of different assets that Genesis has. And, you may be familiar with this. One of the things was these several loans that Digital Currency Group, that Genesis made to Digital Currency Group. And so you've got, I want to say, in excess around 500 million worth that was due in May of 2023 that DCG had to pay back to Genesis. And then you have a 1 billion plus loan that Genesis made to DCG that is due in 2032 and had like a 1% interest rate. And so, and some of the, I believe the loans, one of the loans that was made that's coming due in May was made in Bitcoin. And so what some of these questions that are going to be raised is, we're getting into, for better or for worse, the same old problem of what happened with the financial crisis with digital assets, which is that we don't know how many people have a claim to a particular Bitcoin. You can see the Bitcoin on the ledger, that's immutable. It can always be tracked, but there's nothing that prevents side agreements, written pieces of paper between companies that say, I'll loan you out this Bitcoin, and then they loan that same Bitcoin out as collateral to somebody else, and you don't really know who has ownership of it. You know it exists, but you don't know if there's multiple claims on it. And so in that declaration itself, this January 20th declaration, there is going to be a quote investigation by the Genesis law firm, or the law firm representing Genesis in the bankruptcy, as to what exactly was going on with these loans that Genesis made to Digital Currency Group. That's a subsidiary of Digital Currency Group. Were these fair loans? Were they made at a quote arm's length transaction? There's something shady about it. A 1% interest rate obviously is well below market rate. So what's going on there? Right. The results of that investigation are supposed to be released in 45 days. So we're talking about early March. They could be redacted to be in the public filings, but there's still a lot of problems I see on the horizon, especially for Digital Currency Group. And how much in this bankruptcy there's also talk in that same filing of what is Digital Currency Group going to have to pay back to Genesis that other creditors can get. And so it's a mess. It's going to be worked out over, a long period of time, or, everybody in a back room's got to hurry up and say, okay, fine, we're going to take this loss. We're going to take these beatings here, and let's get this all squared away so this doesn't publicly become a disaster. But that's all happening right now. You saw a little bit of it spill into the public with the Tyler Winklevoss and his tweets. But it's a huge mess, and it's going to be fascinating to see what happens. And to what you said, if contagion spreads even more, or have we gotten beyond it?
Well, that's a very interesting point that you made there, because although the initial fear, uncertainty, and doubt regarding that issue could potentially, bring the markets back down a little bit more, you're leading to talk about how there could be a supply shock, because if you have a bunch of claims on the same Bitcoin, right, and all that gets exposed, and Jamie Dimon, the bankers, can make fun of crypto again, whatever they want to call it, a pet rock. But then once we realize, like, oh snap, right, we don't have the actual supply out here that we thought we did, or what I'm saying, like, we're going to see potentially a supply shock after that. Is that kind of what you're thinking could happen there after that gets exposed?
It's possible. I don't think it might be as big as a supply shock that really affects the market, because this was, maybe I'll pull it up off the top of my head. It was less than, I want to say 200 million worth of Bitcoin, this particular loan.
Okay.
But, it's not as if that's the only loan like that out there.
Sure.
So, it's the contagion issue, is how many people of all these players, Three Arrows Capital, Genesis, Gemini, Silvergate, FTX's seemingly endless subsidiaries that we're still learning about. If we get to a situation where, there's one Bitcoin being traded 1,000 times, just like in normal banking, welcome to the scene, then we are in that situation where it's like, wow, we didn't have as much Bitcoin as we thought. And then, that could be a great driver, a great narrative, and a great driver for increasing the price.
And that's kind of speculation, right? But like you said, it could cause people to say, I want to get my Bitcoin on my ledger. Like once again, we've started to realize this with the FTX and the exchanges collapsing, but that would be an even further incentive to say, I can't let anybody have possession of this property, because they might have taken out a loan, they might have traded it 100 times over. And so not only would it kind of create a supply shock in that sense, but people removing even more crypto, more Bitcoin off the exchanges, right?
Yeah, that's exactly it. And it goes back to the fundamental purpose of crypto and digital assets is, not your keys, not your crypto. And, I'm not for putting 100% of your digital assets on a hard wallet. I don't begrudge anybody that does. That's just not my personal thing. Especially because one day it was the only time I've ever flown private before in my life. And the way they do bags there, I just left my bag there and it stayed with the plane and at the private airport. And I came home and I told my wife and she's like, oh, wait a minute. Didn't you tell me that I'm like, don't worry. You know, I have all my ledger nanos. She's like, but didn't you tell me you put your keys on the piece of paper in your backpack? And I was like, oh my gosh, I did. And so anybody who decided to open that could have, and who knew what that, you know, ledger paper was, could have just siphoned all my funds. And so I had to stay up the whole night moving everything. But anyway, I say that, which is, you know, yes, you should have it. Yes, you should do a better job storing everything than I did in that situation. But I do like having some of it on an exchange or, you know, for example, Fidelity is offering crypto now. But when you do that, you just have to know that when you get into these bigger exchanges, these centralized places, you might not be able to have access to that crypto. So I just don't like having any significant portion on a centralized exchange or authority as long as I have to.
Yeah. Now you kind of mentioned there FTX. We're still seeing this saga unfold and that story. I wanted to open it up though to the broader conversation. We're not expecting Congress really to get much done here. We got a little switch, a little political dance taking place in DC, as it always is. But I wanted to get your thoughts where we're at. John Deaton just said that he thinks it's unlikely that we could get Congress to give us some regulations and rules of the road until maybe even 2025, like after the 2024 election is when he's thinking we might. And he says that might still be early in that prediction. So what do you think, Fred? Is our Congress going to get it together?
Well, Congress will never get it together in its current form. So that's wishful thinking. However, I think there's a lot of validity to what John's saying by 2025. I think that's too late. I do think something could happen by the end of this year. And I just say that from conversations I'm having with Congress people about legislation and moving it. Could they be blowing, you know, smoke up my direction? Yes, but I don't get that sense. But we're going to know a lot more in the next month or two.
Okay.
I'm not a big fan of federal Republicans or federal Democrats. And so, you know, I'm hoping there's a changing of the guard in the sense there's going to be a little more accountability of you know, unelected bureaucrats like the SEC with the new Congress. We'll see. You know, they've got a little bit of a grace period before I'm going to give them a little bit of a grace period before they start getting things done. But there's a lot of bills out there. So there's a lot of structure that they can work with to get something passed by the end of the year. Again, a lot of people are talking about it. A lot of people that know nothing about crypto Congress-wise. I'm trying to help educate, are getting educated. You know, there's tie-ins to a lot of the Freedom Caucus people. When they get an explanation of how this ties into those principles of freedom and liberty, they start being like, oh, that's what it does? I thought it was all a scam. So there is, in my opinion, a realistic push for it. And, you know, I just said at the very beginning of when I was getting involved in public commentary on the Ripple SEC case, that's the easiest way to fix everything, is just to get a law passed that negates the whole case, because litigation can run for years and years and years, favorably for Ripple or favorably for the SEC. And you can't stamp out that until you get either a settlement, which gets rid of all appellate rights, or you get a law passed.
Right. So you're saying that hopefully we can get something done here sooner. Let's talk, since you brought it up real quick, let's talk Ripple versus SEC timeline real quick. You said in March, we're about to get a ruling in the Genesis bankruptcy. Is that what you said?
No, there'll be that's going to roll on for a while. March is when there's certain deadlines in a bankruptcy.
Okay.
Of when you have to put forth certain plans and things. And one of the proposals that was in this January, again, this is all very fluid, and these are proposals, but one of the proposals was the lawyers for Genesis will complete their investigation of the loans from Digital Currency Group to Digital Currency Group, and they're going to basically release a report of saying, were these valid? Were these arm length transactions? Did Digital Currency Group screw over Genesis in doing it? That's coming out in March.
Okay. Yeah, I just asked because there's a few other things that are coming up in March. The most recent speculation in the XRP community and from some of the lawyers, the timeline that we're kind of expecting is to get a ruling from the judge by March. Is that kind of what you're seeing too?
I've gone back and forth on this. And so a long time ago, I was hoping that we were going to get it even, before by Christmas. But when certain deadlines started getting pushed back, I kind of abandoned that idea, in the summer and early fall. Then I thought maybe in terms of a settlement, a ruling on Ripple's experts and the SEC's experts, that's a motion that's pending. Because that's critical to how each party is going to evaluate their case, if their experts are allowed to testify or not testify, or about certain subjects. And then James Phelan basically brought something up that I kind of agree with that I didn't think of, which is she'll probably issue that ruling on the experts at the same time as the summary judgment ruling. It just makes sense. So then that kind of pushed everything back. I think given that we haven't had a ruling on the ceiling issue yet, which even that she might say, I'm just going to wait until I'm going to do everything all at once. There's no rush for me to make a ruling on ceiling. I don't think that's as likely, but it's possible. I think we're looking sometime in March, maybe even April, in terms of when we're going to get a response on the summary judgment motion.
Yeah. And I know that Jeremy Hogan had just chimed in, and he said that basically in most of these cases, the judge is kind of expected to get a ruling out in 6 months, or they get on a naughty list is what he called it. And so he said the timeline started September 15th. So obviously we'd be getting kind of close to that timeline too. So yeah, it sounds like in any normal proceeding case, we would be getting pretty dang close to a ruling from the judge, right? And there's still a couple of pending motions, like you said. But I call this the most staged lawsuit in the history of the SEC. So who knows? We could be here for another year or so, or longer.
Yeah, I think there's that naughty list is basically a rule that says are these pleadings, how long do they stay in your chambers awaiting decision? I've had federal cases where a summary judgment sat on a court's desk for over a year, which is just ridiculous. And Judge Torres has never been, I just went back a couple years and she hasn't gotten herself on that list. And so, you would expect that it would be by March. If September 15th is the deadline, Jeremy's probably right. I don't know if the deadline means when something's fully briefed or not. Because that I don't think was fully briefed until maybe September 15th was when they did their replies, but I thought it was a little bit later in November, maybe. Either way, we're talking about a couple months here. So, it should be at least, March, April, I would think at the latest, because Judge Torres knows this is important and knows a lot of things are riding on the case, and she's pretty diligent and prompt.
Yeah, and it was interesting because once again, Brad takes the world stage over there in Davos, and he alluded to how, there's so much riding on this case, not only in the United States, but also being recognized at Davos with the financial elite there. And so it's been interesting. Now, there was comments circulating, Brad, obviously representing the Ripple and the XRP community so well, I think, over there, and class act always. But people were commenting on kind of his posture about how, saying that really he didn't expect any sort of settlement to be taking place, just based off of kind of the way the SEC's standing up against this. But you were one of the lawyers that commented, and you said here, I agree that there are likely the highest level of negotiations going on right now, and settlement is possible like any day, but I still lean towards summary judgment decision happening first for many reasons. One, being after seeing Nexo, EOS, and BlockFi settlements with the SEC, there is no compelling reason to me for the SEC to not settle with Ripple, move on, and keep the present state of case law ambiguous. To me, now that 2 years of litigation is in the rearview mirror, all signs point to the SEC really, really, really wanting to get a court decision. So you are kind of in that same boat, thinking that maybe a little posture from Brad, but most likely there's some conversations happening behind the closed doors.
Yeah, and that was just a great read through of a great tweet. So thank you very much for that. And I would just say, from being on cases like this, massive cases, when I was a little lower on the totem pole, but also just from my own practice where, we've got not $1 billion, I don't have personally $1 billion cases, but, multi-million-dollar cases. You always throw out, and they've had settlements, they've had mediations already, settlement discussions. And so Brad's been very clear, XRP can't be a security moving forward. That's got to be the biggest hangup is that issue with the SEC. That's obviously what they're not agreeing to, or at least the terms on that they're not agreeing to, which is why there's no settlement. Because, if you take a step back, the SEC loves getting money. I mean, really, I think, and this is the bias in me coming out, especially as a plaintiff's lawyer who sues the government frequently. They want their money. It's not about protecting the average investor, because they don't, with these accredited investor rules, with these, slap on the wrist fines with these huge banking industries, the revolving door of SEC to Wall Street, back again. Missing Madoff, missing Enron, it's a money game. And if they, the calculation has got to be, we can't let this be a free for all with companies issuing their own tokens. And we have to be able to prevent, there has to be some level there where we have some say involved in how these tokens are issued and sold. And we're going to make Ripple the poster child for this. I think they did or underestimate how much Ripple was going to fight. But, why not settle for, they alleged $1 billion. Typically settlements are a lot lower. But I personally believe that Ripple would gladly write a check for $2 billion if the SEC said, okay, fine, SEC, we're not going to go after XRP. If they got the clarity they wanted, why not? Because they would have so much money immediately upon that settlement that $2 billion would be nothing. So there's some hang up there. There's some reason, and it's either the SEC all by itself, just wants this power grab, or there's some political element to it where other forces that we don't know about are saying, I don't care how bad you're losing or what's going on in this case, you're going to keep it going. And if that's happening, the bad news is if SEC does lose, they can drag things on, with an appeal. So, there's also, if you want to go down that route, you can also say it's more of a staged lawsuit. I don't really buy that, because too many things can go wrong in litigation. You can't control the judge. So, but there's elements of that are possible too, if you go down that route.
Right. Just based off the fact that you had Ripple in DC setting up office in their offices. We see the calendar meeting with Jay Clayton. It's like, it maybe not staged, but just the way that they brought this about after Ripple worked to be one of the most transparent in the space. Now, it's interesting that you say that Ripple could settle for $2 billion and gladly do so, because I've been in the same camp. A record-breaking settlement. I mean, this would be headlines and it would be a win-win deal. And many people, they are misinterpreting what Brad's saying and saying that he doesn't think that a settlement is likely, and saying that people are saying that Ripple's not going to settle by any means. It's like, no, you guys are misunderstanding. Brad has very clearly said if they get clarity on XRP, they'd be happy to settle up, right? And then he continues to remind us, as he did once again in Davos, that they're sitting on over $1 billion cash. And then, of course, we know that they get 1 billion XRP released to them each month. They're sitting on, about almost 50 billion in the escrow. So they have funds. They're making money. They actually were just renting out one floor in their San Francisco office building. Now they're renting out the whole damn building, I'm pretty sure. So they have some funds. They have some ability. And I think, like you said, as long as they get clarity, they'd be glad to move on. Now, what's your take? Because Brad says that when the public sees the corruption that's taking place behind the scenes, they're going to be, pretty outraged, and that he actually called the SEC's actions embarrassing at Davos recently. Do you think, obviously we're just in speculation right now, but how likely do you think it is that we get to see the Hinman emails and some of this other stuff?
Yeah, I think it's highly likely they become public at some point, maybe not necessarily in this case, but through freedom of information requests, now that everybody knows they were so hotly contested. What I think, and I've said this before in other venues, is, in my own litigation, like in nursing home litigation, for example, I always fight for emails from high up corporate executives, because people, and everybody, again, I've said this before too, but everybody listening, always send an email like you're okay with a judge reading it, because you never know, one day a judge might be reading it. So people rarely do that, though. And I'm going to not come out here and say I send every email like I think a judge would read it too. There's definitely some emails, if you cracked them, I'd be like, oh crap, I can't believe I actually put that in writing. Which is why I also have a 60-second delay on every email I send, because a lot of times I hit unsend before it goes out. But anyway, the executives of these large nursing home chains will say something like, we got to get the census up. We need heads in beds. I don't care, what you got to do, keep them in the bed, run out extra PT so we can get an extra, I'll make an extra $2,000 a day if you can squeeze out 30 more minutes of PT from this frail, elderly 88-year-old. Hey, listen, if you can't, treat everybody's pressure sore, then that's fine. Just put, that you did, and we'll go on. It's the cost of a lawsuit is less than generating all this revenue. And they fight so that I don't get those emails, and they try and hide them. And, it's a whole side litigation in and of itself. But the reason they fight so much is because people talk like that in emails, and it looks terrible, even if it doesn't have too much to do with the actual case. Sometimes it does, sometimes it doesn't. And so I don't think there's any difference here. I think with the amount of people that were on those email chains, you've got emails that say things like, oh, this is great, because we're giving it to Ethereum, but, everybody else can twist in the wind. Oh, let's be as purposely vague as possible so we don't give any clarity. What about XRP, Bill? Why don't you say anything about that? He might be like, well, because we're going to sue them in another couple of months, and I'm really leading the charge on suing them, or like screw Ripple and screw XRP. You probably have things like that in those emails, almost assuredly, and that's why they're fighting to keep them hidden. And even the judge said they might not go to the weight of the case, more towards impeachment and credibility of certain witnesses, but you put an email like that in front of the jury, and they're like, this guy is a piece of S, and all of a sudden they won't buy into the whole defendant's theory, and Ripple could win, just on the fact that they don't like somebody.
Right. The email to Bill Hinman from Jamie Dimon saying you need to sue Ripple and stall this thing out while we launch JPM coin and try to do something.
Yeah, and the sad thing is there's probably a lot of emails like that on his private Gmail that nobody even knows about, and that has been kept hidden. So and that's the thing is I don't even know if they have all of them, or if the SEC produced all of them. They could be hiding some things, which is sad. But the ones they got are pretty bad already. That Brad is confident, saying something about it. So. I think they're of that nature where XRP is explicitly referenced, and there's no real good reason as to why it's not included in the speech, and that's why they we're fighting so hard to now keep them hidden, even though they've had to turn them over to Ripple.
Right. And now one last thing on this, because people always ask me, what if Ripple loses? I'm like, well, there's not too many ways in which Ripple actually loses, they're gonna go away, and this is gonna be a bad outcome for them. Like settling up and paying the SEC $1 billion, I think that they would, not obviously be thrilled about, but is that a loss? As long as they get clarity, they pay a fine, move on. What is the worst case scenario that you could potentially see though, Fred?
Well, the worst case can get pretty bad. But what I'll say with this framework is the Howey test is not the District Court of Florida test. That was a Supreme Court test, because the Howey Orange Grove, what's a security, started out in Florida, went to the Court of Appeals, and then went to the Supreme Court. If Ripple is going to go all that way, we got another 2 years left. Either way, whether whoever wins at the trial court level. And so, the worst case scenario is a total loss, library style, like at summary judgment for Ripple, and I think there'll be a huge crush to XRP, but I think there'll be a recovery afterwards, because Ripple would appeal. They'd probably move their business operations, outside of America while the appeal is pending. And, we just don't have that clarity for another couple of years. At the same time, at summary judgment, there's a lot of different issues going through the court. And the court, the standard that everybody's got to remember is there's no material fact in dispute. All I have to do is go on these facts and the law, and I can make a ruling. And it's very hard for a judge to do that in a hotly contested case. So I don't think there's going to be a lot of clarity or a lot of finality in the summary judgment issue. I think the ruling is going to be somewhere along the lines of, and I'm 60-40 on this, that 60% chance that there's a 40% chance, I think, that Ripple wins outright, where Judge Torres says even the way Ripple sold XRP, it's just not a security, it's not an investment contract, this is over with. I think that my 60% scenario is, she says, there's no written contract, but based on the dispute, even though it's thin, the SEC can at least get to trial on some of these claims. But at the same time, I think what's going to happen, and the SEC has been backing away from this, and they backed away from it in our amicus brief that Reaper submitted, is this secondary market issue, which is, I think, instead of what I want the judge to do, which is to say the XRP in the secondary market is not securities, I think she's probably going to ultimately rule, hey, the SEC alleged that XRP everywhere is a security. XRP itself is not a security, just to make that clear. And everything in the secondary market, from what BitPay does to what the individuals represented by John's amicus brief does to what Reaper Financial does, this isn't before me. And all these amicus have shown is that there's a lot of use cases outside of what Ripple does. So the SEC, I'm not going to rule on what Reaper does or what BitPay does if XRP is a security in that situation. But I'm also going to say that no part of this case will affect that, because the SEC hasn't properly alleged it, and the facts aren't before the court. And so I think that's going to be the major win at summary judgment, is that while you don't get super clarity on XRP in the secondary market, you get the fact that the SEC went too far, and now they're going to have to bring suits against everybody using it. And there's just no way they could possibly do that. They could pick off a few people, but as long as everybody holds firm and continues to use it, they just can't go after everybody.
So in that type of scenario, then would the judge just be making kind of not giving us clarity on XRP, but then looking at Ripple's sales of XRP, and that's what she would be putting her focus and ruling would be against, would be Ripple's sales of XRP?
Yeah, so that could be, I just don't think she can make a ruling on the secondary market, other than the SEC hasn't brought any facts to show that everything that happens on the secondary market is a security. You lose on that, SEC. I'm not going to say it's not a security, but there's no way that you've shown that it is. So that's kind of like, it's all for another day. And so in a loss for Ripple, the judge could say, whenever Ripple sells its XRP like this, like it's been alleged, that's a security. So then Ripple therefore could either, based on the ruling, change the way it sells XRP, and the SEC can just sue it again. Or it could be totally screwed on the way it sells XRP. I don't think that's likely, but that's like kind of the worst case scenario in my mind. The judge, I don't know how she says this whole made up Hinman speech of it's a security before, but now it's not anymore. That just is kind of like a made up thing that doesn't seem to track the law. So she could split the baby by saying, 2013 to 2015 sales are securities, but now they're not. I don't see her as being the kind of person that does that. So, I think it's going to be a situation where she says, there's enough facts to say that maybe Ripple did. We're going to let a jury decide whether Ripple actually marketed it as a security.
Yeah. Yeah. Well, I appreciate you giving us your thoughts on that case. Now, you have filed a case here. Let's get into this. Woody versus Coinbase. You filed this in California, and this is a class action lawsuit, folks, against Coinbase in regards to our Songbird and Flare. So what made you decide to take up this action and make this claim, Fred?
Well, I think in most class actions that happen, it's a lawyer gets screwed over and it pisses them off big time. And they're like, I'm going to start a damn class action and show these guys they can't screw me over or everybody else. And that's, I personally think that's how a lot of class actions happen, because that's how I get most of my ideas. And when the Songbird token dropped, I got it on Uphold, and a little bit later we got it on Kraken, and we just never got it on Coinbase and a couple of other exchanges. I'm aware of everybody that's been reaching out to me on all the other exchanges, and they're next. And I personally tried to get in touch with Coinbase with my own account, and surprise, there's no customer support, no meaningful customer support, there's no meaningful response. And so I was like, well, these guys got to get sued. And the thing is I can't sue them in a class action as a lawyer. I needed to find someone willing to serve as a class representative. And I can't get into the detail too much, but I had a lot of conversations with people about being a class representative, and ultimately, right before file time, they, for various reasons, they chose, I don't want to be the representative. And so I give mad props to Dallas for being able to comfortably say, I want to put my name out there, and I want to, help lead the charge to help everybody that was screwed over by Coinbase. And one of the things is the lawsuit originally started as just going to be about Songbird, and then Coinbase pulls the same crap with Flare, and says aloof, vague, ambiguous, we're going to give it to you at some point, we think before the first half of the year. And that's just utterly ridiculous. The value being lost, the delegation and the rewards that are being lost by people that's their Flare. Coinbase said publicly, everybody that has XRP on the date of the snapshot is participating in the snapshot. And we're just going to go through the courts and we're going to test this legal theory out that, you're breaching your fiduciary duty, you're committing negligent misrepresentation, fraudulent misrepresentation when you say, we're going to participate in this airdrop, tell all of your customers if they put their funds on your exchange, that you derive benefit from, they will be participating, and then say, no, we're not going to do it. While at the same time, taking possession of those airdrop tokens and keeping them and using it as your own little slush fund. So, we're looking forward to seeing what Coinbase is going to do. And hopefully they're going to do the right thing and say, we made a mistake, and we're going to give everybody, now that you forced us and put our feet to the fire, you're right. But I don't think that's going to happen. But we'll see.
Would you potentially withdraw the lawsuit if they decide to just flip the switch and make everything right and we would be all good? Or is it too late for that?
It would depend on how they make things right. Because, one of the things, just so everybody knows what the class action is, a lot of times you might get a postcard in the mail saying you get a free, piece of food at this restaurant, or you got a 50-cent coupon, or you get credit monitoring for free for 12 months. And some people in this class action that I've talked to that want to get interested, they're expecting less than a couple $100 worth of Songbird and Flare. I've got other people that had millions of XRP on there and, have a very substantial amount. And so the amounts vary widely, but it's all easily proven for a class. You had blank XRP, you get blank Songbird and Flare, based on the distribution. And so that's the easy part of it. If Coinbase wanted to do the right thing and said, we're going to give everybody their Songbird and Flare, that would largely, be the end of it. There would just have to be some type of additional mechanism to some extent for Flare, because it's only been, out in the wild for, maybe 2 weeks now. But, the problem is with the Songbird, which, there's a tremendous opportunity lost, because I think it went as high as 74 cents, 75 cents a coin, maybe even higher on other exchanges. And now maybe it's at 7 or 8 cents. I'm not sure where it is. I haven't looked in the last week. I know we've been in flux. But, there has to be a little bit more than just giving everybody what they want back, because of that, the damages that were done, especially on the Songbird side. But, it's all part of a negotiation and the give and take. And, if the class would be served well by, some early action by Coinbase, well, everybody gets their stuff back. I don't need to say I deserve this super high attorney's fee, because, I did a lot of legwork and prep work, and we did everything. But, I tell everybody, and it's just my philosophy, that I'm already rich. And I say that where I'm not a multimillionaire, but I've got a house over my head. My family can eat, freely. We've got access to medical care, good education. There's not like a lot of things that I need. And, I really am more about just doing the right thing, holding people accountable. It's just part of my nature. So yeah, the short answer is there's a lot they could do quickly to make it all go away. And I hope they do.
I want to hone in on the damages and the value of those damages. So have you guys made a claim on that amount yet? Or is that still, I don't know how these work.
So it's not a specific amount in the complaint, because it's not necessary at the pleading stage to get to that level. If you find a class action, you do have to allege over 5 million in damages. It's very clear just from the amount of Songbird that it was apparently, looks like it was sent to Coinbase, is well over that amount. The issue that's going to be a little tricky on the damages side in all of these types of cases is obviously not everybody, when they get Songbird, some people, not everybody sells at the top of the market. I'm living proof of that when we went through the last bull run. And so that part, is a little more complicated in the sense of a class action, but, it's obviously very easy to know what everybody had on the date that the airdrop happened and what the fair market value of was there. And so, you can go by a damages aspect of, your typical, in these legal cases, statutory interest from a, what the fair market value was when it dropped. Whether you sell, didn't sell, whatever, you lost, that statutory interest from then till now, not having it. And so those are easier things to prove. When you're doing a class action, you have to make it so everybody is treated the same. And so to avoid some of those questions, you've got some easier theories to fall back on.
Yeah. Okay, so you guys really aren't at the point yet of putting a dollar amount on it and figuring out what the compensation would be. You kind of just have to wait for the judge to actually hear this case first.
We got to get through discovery a little bit more and kind of see what Coinbase's position is going to be on that one. And the easiest factor of it, which is why I was hedging a little bit on your question, was give everybody their Songbird, give everybody their Flare. And, if we can work, that's 85% of probably the case. And, if we can work on coming up with something that's fair for the damages caused by everybody not having access to their funds, then that's great. But, we'll see what they do. I think, what I would expect to happen is that Coinbase, and they might not, maybe they will, when you look at your terms of service in all of these exchanges, and really, anything you're clicking on online, take a moment to go through it. It's got to be bolded, so you can kind of scan through the agreement and get to the bold part. But there's an arbitration agreement in the terms of service for Coinbase users they force you to agree to, which basically says you can't sue as a class action, you can't sue as in court, you got to arbitrate. And the rules for consumers are just stacked up against the consumer, where it just clearly favors the company. Coinbase has lost a couple of those motions already in the Northern District to compel arbitration because their agreement is so one-sided and outrageous. It's what's called unconscionable in the law. And, so if we have to fight to invalidate that, we'll fight to invalidate it. Coinbase actually has a case right now pending at the Supreme Court about one of its arbitration agreements. I think it's about a Dogecoin sweepstakes giveaway. And so, that'll impact the case too, to see what happens there. Well, it could, it may not, depending on the arbitration agreement, but, there's a lot of procedural moves that Coinbase can employ to delay this out. I hope it doesn't. If anybody from Coinbase is listening, you just fired thousands of people, and now you're going to spend millions of dollars on a legal case, where you're just trying to evade doing the right thing. Why are you doing that? That doesn't help your shareholders. That doesn't help your employees. Just give everybody their coins back and let's all move on.
Right. Yeah. And I would like to say that I for sure would have sold the exact top. So I'm going to be seeking, I'd prefer, Fred, if we calculate that in, because I would have nailed that on the TA. No, Fred, I absolutely appreciate what you're doing here, making this claim, taking this action. Recently, many people know I'm on this committee that's working on, figuring out the fair market value of XRP, talking about corporate governments, and also talking about the changes to the commercial law that are going to impact all digital asset investors. And so I've been telling my audience, guys, at this point in time, we have to mature this conversation, and we have to bring on board lawyers like Fred and others that are going to help us, fight this legal battle. And so one thing that we were talking about before the show was the changes to the UCC that are being proposed right now. And this is the Article 12 part of it. There's a take-free rule in there where basically if you don't make a claim within 2 years of losing your property and it's sold off to somebody else, their interest in that property is going to be superior to yours. And so I encourage all of the listeners, if you haven't already, I've been kind of hounding this thing for the last month or so, but if you haven't already, go understand, go read some of these articles about the changes that are being proposed. I think a few states have actually already are close to passing them. In the Article 12 of the UCC, it's an additional amendment that's being made that's going to include controllable electronic records, is what they call them, CERs. And it's basically just digital assets. But in this instance, this is more than just the XRP community losing out on their Songbird and Flare. This would be in the case of if somebody had an NFT stolen from them too. If you don't make a claim within 2 years and that property's been sold off, you may lose out on your rights to that property. So, Fred, I think that it's interesting the timing of this lawsuit, because if adopted as it's being proposed right now, we'd be coming up on some timelines, right? We have already, 2 years since the snapshot, obviously. And then we have, we're coming up on 2 years since the Songbird was released, right? So we're coming up on that 2-year window of opportunity. Are you watching this Article 12 take-free rule, the changes to the UCC, and applying this to your case?
I wasn't until you actually brought it up to me before we were going live on the show, but I was looking into it to try and prepare a little bit. The UCC stands for the Uniform Commercial Code, just for everybody else in the audience. And it's been a very standard piece of property law for decades. There's a lot of different sections. What's a contract? What elements does a contract have to have for it to be valid? There's, if you're selling fixtures in real estate versus if you're selling, services or goods, and the goods get to your bucket of strawberries goes bad on transit, who's responsible for what. So it's a very integral aspect of American law. And Section 12 is a whole new section to govern digital assets. As you said, there's CERs, CERs. what was it? Controllable electronic record. And so from the research that I try to do to prepare, it's basically taking a lot of what's already in the UCC, but having a specific section for these cryptos, these digital assets, these CERs, where the usual rules apply, but they're tailored to some of the more unique aspects of the blockchain and that type of technology. And this take free rule, that just from what I was trying to look at is similar to, another Article 3, which is, when you also take a negotiable instrument and you're not aware of any prior claims, or you're not aware that it was procured from fraud or duress, by the person you bought it from. And so, yeah, take free is basically if you don't have any notice or knowledge when you take the asset, then you have a valid claim to it. There's always exceptions and exemptions, but the basic rule is as long as you don't know and reasonable diligence or search wouldn't lead you to find out, then you'll get it. And so, for everything that's happening now, it's not going to, for actions and events that are happening now, it's not going to play too much into it because you have to wait for the states to adopt it. And, it depends on which state you're in. And when they do adopt Article 12, there'll be a certain date of when it's effective. Usually they're not retroactive, they're future. Some other states have already adopted Article 12 like provisions, but they're not uniform, like what the UCC stands for. So it's a step in the right direction. We're moving forward, and that's all good. In terms of where it's all going to play out, it's hard to say for right now, at least for everything looking backwards.
Yeah. Yeah. And like I said, like you said, basically, this is the same commercial code and laws that apply for doing the rest of business. What this is applying to is the controllable electronic records. And they're very clear that it's not aiming to define these as securities, commodities. It's really just applying the laws surrounding the transfer of them and possession of them and title of them, right?
Yeah, exactly. And so, I think you were always hoping as a law student that the essay portion didn't have a UCC contract question on there because it could get complicated. So I'm not, a super well-versed expert on the UCC aside from kind of some of the general provisions. But yes, the bottom line is we're talking about goods and services and acting in commerce, and what are general rules that everybody can rely upon when they're engaging in commerce, so we can be as fair as possible, like the opposite of what the SEC does, where they have all these secret rules and they don't tell you about them until they sue you. For example, in that take free rule, I was reading, I was again, this very quick research, but for NFTs, for example, this take free rule in Article 12 seems to indicate that you might own the NFT free and clear, but as long as you didn't think there were any other claims to it. But that doesn't mean you get the same rights that go with either the license or any other rights associated with the NFT. And so just a very quick research, that's kind of like a difference that they're thinking about for NFTs in this situation. You get the
basically
NFT
with
itself.
Marvel NFTs, you would get a right to that NFT, but not to Marvel's property.
Yeah, so it doesn't automatically mean that if you have a Deadpool NFT that you can create a story on Deadpool and sell it, or even necessarily like a story just on your NFT of Deadpool, and it's only strictly related to the NFT that you own. So, again, you would get the NFT of Deadpool, but you don't get any of their licensing or rights to the story, the images, the other IP, is what's currently being contemplated, the way I understand it.
Yeah. Okay, Fred. Well, I couldn't let you leave without getting your thoughts. And what I want to ask of you is just, in a mature conversation, everyone's offended by the XRP buyback, $50,000 price, this and that. And like I said, We went past that and we got to a conversation about the situation of our corporate government, how far in debt we are. We have a reserve currency status that's being lost, 30 trillion in debt, over 100 trillion in unfunded liabilities. We talk about the changes to the commercial law, which I learned about that from the committee, and Jimmy Valley sending that over to me. And when it came across my desk, I said, wow, this is going to impact not just XRP holders. This is going to impact everyone that's invested in digital assets. But I'm not going to ask you whether you think XRP is worth 50K, but I just wanted to ask Fred, as we get some lawyers to come and help us poor XRP holders out here, what do you think is the right approach for, how we can recover the damages lost that were done to the XRP community? There's talks of further class action lawsuits getting filed. Do you think that it's appropriate and mature to be having those conversations about the law, the legality, the changes that are happening to these laws and how they could impact us?
Oh, I mean, of course, there's a lot depends on how Ripple SEC resolves, but if it resolves heavily in Ripple's favor, there's much more ammo for John Deaton to go forward with his class action against the SEC. There's much more ammo for me to go forward with, our action against Jay Clayton and William Hinman personally outside of the SEC. That's one option.
I can't believe that I forgot that you'd filed that too. I totally forgot that you had filed that, because I'm pretty sure that's when I first had got onto you on Twitter, was when I saw this. And once again, I am just so thankful that we have lawyers like yourself that are stepping up and taking the side, getting on our side of the table against the SEC and all these other corrupt entities that are working against us.
Well, thanks. And just, if Congress isn't going to do it and, these agencies aren't going to do it, it's got to be you using a lawyer. So again, I can't file. Well, I'll get to it in a second. There's one thing I did file that I'm kind of doing as, in a way, just on my own, but you got to have people step up. And I just always say, you don't realize, everybody that's listening, how important you are and what a critical role you can play. Reach out to an attorney, reach out to your congressman, to somebody, and get involved. You can really do a lot. Getting back to, the buyback and everything, you've got the SEC actions. In terms of the buyback, I'm just in that camp where, well, maybe it's not a camp. I don't completely dismiss it. I don't completely think it's definitely going to happen. That's one of those things to me that could certainly happen, but it's just political. And it's very plausible that at the drop of a hat, after enough people have talked to each other and the super rich and the oligarchs have positioned themselves, that there's an XRP buyback, and everybody, and we, whether it's you get X amount of dollars for XRP, or, okay, now every dollar is, it's almost the same, but a little different. They're reflating the dollar supply into XRP. That's a political move that could definitely happen, or I guess is, not impossible. But, on that front, you could say that about any other digital asset. There's strong reasons for or against, but if the political players align for Stellar or for Bitcoin or for the USDC or for Tether, there's reasons why and why not that would happen. But the bottom line is, I do believe, as you it seems like you might agree, that we've gotten to a very close tipping point, or maybe even we've passed the point of no return with the US dollar as it currently is. Something's got to happen to address all this monstrous debt, not just US, but global debt. Reserve currencies always go away at some point. What's going to be the new thing? And is XRP going to play a role? I think that's a very valid question to have.
Yeah. Yeah. And like I said, I would have sold my Songbird at the very top. And if we're going to make a claim against the SEC, we might as well start at 50K and let them work us back from there. Right. That's, and like I said, for me, it's so much more. And many of us on the committee and, like yourself, we're not hoping for a buyback. I think that the concern and the protection that we're trying to establish is against them saying that we can't own XRP. It's some type of security or new hybrid security, or in the interest of national security, we're going to have to buy it back. Just like, and we do have a precedent with gold once again. And so I think that for many people, they need to look past the 50,000 buyback from the Fed, us just trying to have the Fed bail us out so we can set sail on the yacht. It's so much more than that. And we bring up real issues. And once again, the fair market value of XRP, we could be talking about that till the sun comes up tomorrow, right? And we still won't come to an agreement within the community. But understanding the situation that our government is in, how desperate of a situation it is in saving the reserve currency, acknowledging the debt that, obviously we're on another debt ceiling limit has been reached once again, they tell us. And so it's a serious situation. We got to do something about it. It's not about XRP is going to have all the money flowing on it. XRP is going to be the new reserve currency. I think that it could help facilitate our fixing the debt in the currency crisis. Rosie Rios could maybe help broker that transaction between the Treasury and Ripple. But that's just me in a hopeful, perfect world where Ripple would cut a deal with our Treasury and we would build the new CBDC on the XRP ledger. And, that's the perfect world scenario that's not going to play out. But I want people to understand their rights as digital asset investors, the changes to the commercial code here. And then I want to get to that adult conversation about how do we fix our country? It's so much more than just us XRP holders making some money and some sick gains. I want to fix this country.
I mean, those are all excellent points. And I think one of the first things is everybody listening has to get a little more involved on the political level. Federal officials and state officials, probably more know who your state people are, but no, I take that back. Equally know your state and your federal people. They do reach out. Most of them will get back with you. And, I had some trials going on in August, September, and, I started too late in trying to generate some buzz for some pro-crypto candidates, because that was the only issue I was thinking about for this last midterm election. So get out there, get involved, just reach out and, be diligent, because you'll get a response, a canned response from most of them, not all, but most politicians just give you a canned response. That's why you got to be after them. And, you can make some type of change. The thing to remember with, another thing with this whole XRP Ripple issue and why there's definitely a political side to it, as much as we want to talk about the law and everything, is that if Ripple has, what is it, like 44 or 45 billion in XRP escrow left, and they have, I think, anywhere from 6 to 10 billion, as well outside of the escrow. You have to think of the way the SEC thinks about it too, and maybe other people that we're not aware of and high up in the government, is if all of a sudden XRP went to $10, well, then that's all of a sudden 500 billion that Ripple has some type of control over. If you get into pre-allocation with this escrow and all that, maybe, but they at least have it in escrow right now. If it gets into $100, then all of a sudden you're talking about trillions, lots of trillions. And that one company has, that's now all of a sudden the biggest company in the world by far. And so that means a lot, and that is a lot of power change instantly. And so I think there's that element of it that you just got to keep in mind, is that, whatever the laws are, if somebody's going to be getting too big, the government's going to have an issue with it and is going to want to have some type of say in that. And so I think that's a underlying issue that we have to keep involved in this case going forward, because of that aspect.
Right. Well, Fred, like I said, I absolutely appreciate that you've made that claim. In fact, I was one of the dumbasses that had their XRP on the Coinbase exchange at the time of the snapshot. And so I have not received my Songbird and Flare. So can the average XRP holder that was impacted by this join your class action lawsuit?
Yeah, if you're interested, just go to contact@hodllaw.org. Sorry, you can go to hodllaw.org and go to the contact page and fill out a form. And it'll go. We're incredibly inundated with people that have been indicating their interest. So hopefully we fixed it where you're getting a confirmation that that we got your form. You can send an email to contact@hodllaw.org. We're kind of putting together a database of everybody so we can send out emails, giving everybody an alert, a status update. So if you want to get involved, just go ahead and do that. Follow me on Twitter @FreddyRiz. And our firm HODL Law is @HODL_law. That's where I'm doing a lot of the updates for the law stuff. And you didn't ask me, Zach, although I didn't bring it up, but we've got one more major lawsuit that's going on. If you have few extra minutes, I'd like to kind of give a shout out to that.
Yeah, absolutely. Yeah, and I want to clarify one thing. I called myself a dumbass, but many of us were just getting into crypto. Like I had been into crypto before that, but for all the new people, nobody should feel bad or guilty because we had our XRP on Coinbase. Like now, self-custody has become a big thing, getting your crypto off these exchanges, but that doesn't take away from the wrongdoing on behalf of Coinbase. So I just wanted to clarify that point.
No,
I'm just beating
and
myself up, and I have
that's
regret.
a good point. Legally, you were completely smart and sensible, and just hey, Coinbase publicly said on multiple occasions in multiple mediums that we're going to be participating.
Yeah.
Now, as a person that's been in crypto for a while, I guess you could arguably say you were a dumbass by putting it on a central exchange. But with me, I had XRP on a couple different exchanges for the snapshot. Again, this is 2020. I had my ledger, but I was looking at like how to do this and set up your ledger so you're participating. And I was just thinking, you know what, this could be a scam, or this is some way that I'm going to drain my entire XRP. So you know what, I'm not going to get greedy. I won't have all my XRP participate. I'll just let the exchanges deal with it. But the vast majority of my holdings were off on my cold wallet. And I didn't hook it up. So I'm equally a dumbass in that situation. So it happens. But what I wanted to let everybody know, and it's really interesting to me, and is very important, and is a fight against the SEC for their blatant hypocrisy, overreach, double dealing. Is our firm HODL Law? We filed a declaratory action against the SEC in late November, saying, hey, we want a judge to say that Ethereum is not a security under the securities laws. And my firm, HODL Law, is the plaintiff, and HODL Law has Ethereum in its operating account. It uses Ethereum on transactions in the metaverse world. It's used Ethereum to purchase metaverse land on certain programs or certain metaverses that are out there. And the SEC refuses to say if this Ethereum and this use of it is a security or not. And so at any given point, the SEC can knock on HODL Law's door and say, you're using unregistered securities and transacting in them. And they refuse to say, and here's the thing, if the SEC said, yes, we're going to do that, that's one thing, we know. Or if they're saying, no, we're not, that's another thing. But they just refuse to say, after 8 years of Ethereum being on the market. And a declaratory action is something that, you're just telling a judge, hey, you need to say what my rights are. A lot of times you do it in car accident cases. If an insurance company isn't going to provide coverage to their insured, you were drunk, you didn't pay your premiums, and a judge says first, the insurance contract applies or it doesn't apply, and the lawsuit goes from there. So this lawsuit was filed in the Southern District of California, so it's right around San Diego. And we serve the SEC. They've got till mid-February to respond. The fact that, and no one's reached out from the SEC yet. And so I just feel very confident saying that the SEC does not think Ethereum is, or the SEC does think Ethereum is a security. They could have easily said, hey, Fred, why are you filing this lawsuit? Ethereum is not a security. They could have already answered and said, formally Ethereum's not a security, so dismiss the lawsuit. But what they're probably going to do is come up with some procedural delay saying, we can't sue them yet, or we don't have standing. And that in itself should tell everybody all you need to know, that, right now the SEC will go after Ethereum at some point.
Right. Wow. I can already see the title and the thumbnail now. Serving the SEC and class action lawsuit against Coinbase. That's what we're going to have to put there, Fred. That's massive. That's massive, brother. Okay, so let's get this straight. You have filed this complaint. What was it called again?
This one is, it's just HODL law versus the SEC, and it is in Southern District of California, and it's called a request for declaratory relief that Ethereum and the Ethereum network are not securities under the Federal Securities Act of 1934.
Okay. And then we have the class action lawsuit against Coinbase. And then you've rescinded your motion that you did against Jay Clayton. And who else was, what was that one?
That was also a lawsuit against Hinman and Clayton. That's been withdrawn though.
It has been withdrawn. Okay. And is it still on the back burner?
It's still on the back burner. And I think we're going to maybe fire it up a little bit sooner, not necessarily refile it sooner, but there's a lot of kind of baseline behind the scenes things that can be done to just let everybody know that it's not going away. You know, because at the end of the day, this lawsuit against Hinman and Clayton, John Deaton's potential class action against the SEC, it's hard for anybody that held XRP. The people that sold would still have standing, but it would be hard to go forward with those cases if the Ripple SEC lawsuit ends in a way where Ripple goes to $4, $5, $10, because you can say, yeah, if you held on to XRP the whole time, you can say, I was stressed out, this was ridiculous, it should have went up higher earlier. But at the end of the day, if all of a sudden you still had it and you're like, well, you know, the XRP is 4, 5, 6 times higher than when all this bad stuff was going down, it's hard to prove that you actually suffered damages. And so all of that could kind of neatly go away. There's no real point in suing if, you know, a person has made 10x, 50x on their XRP.
Even
really,
if your wife left you because you were still holding XRP. So your wife left you, you lost the house, but now XRP's pumped so you can get it back.
Yeah. So, I mean, those are a lot harder things to prove, why, because if I was the defense attorney, I'd be like, oh, really? Well, here, I think it was, your wife says there are all these other reasons why she left you, not just your XRP bag. So that's why that kind of stuff is so hard to prove. So it really cleans up a lot of things it reduces the liability for a lot of people if Ripple wins and XRP starts climbing higher. So, that's really the best for everybody, and everybody can move on, even though there'll be hurt feelings and a lot of resentment. But it's hard to do that when you're on your yacht.
Well, I'm hopeful that we can catch that pump and that everybody can get their wife back and we can all be happy after that. Well, Fred, that's major, brother. And once again, I really appreciate your work. It's unfortunate at this point in time that we're caught up in this legal political battle, but I appreciate that we got gentlemen like yourself here and that we somewhat still have a rule of law here in the United States. And I just really appreciate you for taking the time to come on the show here today. And let's shout out your platforms again one last time, Fred.
Sure. Really, it's just Twitter and the website. Me personally, I'm at Freddy Riz, FreddyRiz, and then the firm is at HODL Law, HODL, HODL _law. And then you go to our website, which is just hodllaw.org, O-R-G.
All right. Thank you, everyone. If you appreciated this interview, if you could just do me a favor, smash that thumbs up on the way out. Make sure you hit that notification bell so you don't miss any of our future content. And I will see you guys in the next one. Take care out there. Thank you. Thank you, Fred. I am your host, Zach Rector. I really appreciate all of the love and support. If you want to support the channel, just remember that you can start by smashing that thumbs up for me, sharing this content far and wide, and everything else is at my website.